ladies and gentlemen of the House, and on behalf of Governor Nathan Deal, thank you for the opportunity to present House Bill 349 for your consideration. 2 years ago, Chairman Neal introduced House Bill 265, which set up the Special Counsel on Criminal Justice Reform. That council worked throughout the year in 2011 and produced a set of recommendations that in large part, nearly completely, became the basis of House Bill 1176, which this body, which the General Assembly enacted last year. The Special Counsel went on with its work in 2012 and produced a set of recommendations. The first part of those recommendations were much-needed reforms for our juvenile justice code, and those recommendations were in the form of House Bill 242 that this House unanimously, I believe, approved yesterday with Chairman Willard shepherding that piece of legislation. House Bill 349 represents the second set of recommendations of the Council's 2012 work, and they relate to further reforms that we can make in the criminal justice system as it relates to adults. What I thought I'd do is just quickly run through the bill on a section-by-section basis. I do have a summary that I've placed on your desk on my stationery if you'd like to follow it or not. But in sections 1 through 3, that grants the state the right to appeal a pretrial ruling made excluding evidence. The language in those sections represent negotiated agreement between the prosecution community and the Council of Superior Court judges and the administration. There are certain time frames that have to be adhered to in order to exercise that right to appeal, and again, that is agreed upon language. Sections 4 and 5 of the bill go to the real heart of the matter of this particular bill. It allows a judge to use his or her discretion to depart from a minimum mandatory sentence for drug trafficking up to 50% in certain circumstances, and those circumstances are defined in lines 200 to 206 that reflect the approach taken in the federal system. And this is important. If a defendant meets all of those conditions, again, as set out in lines 200 to 206, then the judge may, and that's a key word, may reduce the defendant's sentence. Additionally, the judge may reduce the sentence if the prosecutor and the defendant in a drug trafficking prosecution have agreed to a sentence that is below the minimum mandatory. Regardless if it's an agreed-upon negotiated plea between the prosecutor and the defense, or if the defendant qualifies under the conditions of lines 200 to 206 and the judge reduces the sentence no more than 50%, regardless of which circumstance may be at play, the defendant in that situation will serve every single day of that sentence, and that is not parolable. And I want to make sure that's very clear going forward. Also in section 4 of the bill, we had a case that came out of the Supreme Court called Wilson versus State last year. And the way our statutes are written, the Supreme Court interpreted it very literally to say that in order for the state to have a prosecution on an individual regarding drugs, the state had to prove that the defendant had actual knowledge of the weight of the drugs, which is to say, if an individual is prosecuted for, let's say, trafficking and or having 9.5 kilos of cocaine, the way the statute is written currently, according to the Supreme Court, the prosecution will have to prove that the defendant knew the exact weight of those drugs. Well, of course, that results in an absurdity, and therefore a statutory fix had to occur. The changes in the bill reflect the fact that the person does not have to have subjective knowledge of the actual weight of the drug in order to be found guilty under the statute, and that intent is further clarified in one of the amendments that I'll get to in a little bit. Section 6 clarifies the definitions of active probation supervision and unsupervised probation. Right now, the Department of Corrections has a responsibility in these situations, even in this unsupervised probation context. That creates very much of a resource issue for them, and their resources and energies are much better used in those situations where active probation is necessary. And so it clarifies the definitions of where Department of Corrections has responsibilities on unsupervised probation. I want to make sure it's very clear that an individual, even if they're on unsupervised probation, still has to adhere to the conditions of their probation. If they do not adhere to the conditions of their probation, and they are subsequently arrested and or convicted, then they could have the balance of their sentence revoked as in any other probation situation. I want to make sure that's clear. Section 7 and 9 grant discretion. It's very similar to the minimum mandatory as it relates to drug trafficking. But it grants discretion to the court for departure from a minimum mandatory sentence for a serious violent felony, but only when the prosecutor and the defendant agree on the reduction of the sentence. And again, if the sentence is reduced, we have truth in pleading. They still will serve every day of that potentially reduced sentence. And again, in a serious violent felony, that occurs only if the prosecutor and the defense agree. Why are we making that more stringent than in the drug trafficking situation? Because it's a serious violent felony, and it has to be more stringent. Section 10 of the bill creates the Georgia Council on Criminal Justice Reform for the purpose of periodic comprehensive review of our system of criminal justice. That's fairly straightforward. Section 11, I'm going to skip for a moment and come back. And sections 12 to 15 provide that a judge may allow for a limited driving permit for a defendant or participant in a drug court or mental health court program to use that as an incentive, a reward for compliance with the terms of the drug court program. And it also provides that the Department of Corrections shall assess a fee from a probationer for their ongoing drug screening. As it relates to the limited driving permit, this body passed Senate Bill 236 last year, which allowed for that type of limited driving permit in a DUI court, but we did not do it in the context of a drug court or a mental health court, and this goes ahead and fills that gap. Ladies and gentlemen, you have two amendments that are on your desk. The first one is AM 292151. These are all cleanup technical amendments which clarify and frankly, more artfully word the intent of the bill. There are no substantive changes in that. They just simply clean up and make for better presentation of the substantive points of the legislation, with the exception of one, and that is in Section 15A of the amendment. Again, Section 15A of the amendment, lines 40 to 47. Right now, the State Board of Pardons and Paroles has certain powers under the Constitution and our statutes, and they can go ahead and parole an individual who has who is entirely incapacitated. But there's no language anywhere that we can see that gives guidance as to exactly what that means. What this language will provide in lines 40 to 57 is some guidance as to what should be considered as it relates to the definition of debilitating terminal illness and entirely capacitated, and again, giving guidance in that particular section that comes at the request of the governor's office, and so it's included in the bill. With that, Mr. Speaker, there's another amendment. It's AM 292153, and this goes back to Section 11 of the bill. Section 11 of the bill. What Section 11 of the bill provided is it expanded the use of the child hearsay exception in order to allow for the statement of a child who witnessed another child in a sexual abuse situation and then stated what they saw to another individual, for that hearsay exception to be used in court, which I think we'd all agree and is a very positive expansion of the child hearsay exception. However, in the drafting of that particular provision of the bill, some wording was included that could muddy the water as it relates to the use of the child hearsay exception in certain civil contexts, including child deprivation cases. I want to thank Representative Regina Quick, who pointed this out to us last night, and the circumstance of it was such that we were not able to go ahead and perfect an amendment in time for floor debate today. So out of an abundance of caution, I'm just going to ask you and the fellow signers of the amendment that's on your desk to go ahead and strike that section. We'll continue to work on it over on the other side in order that we not have any unintended consequences kick in. But I want to thank again Representative Quick for her eagle eye on that. With that, Mr. Speaker, I'm happy to answer any questions if there are any, and would ask for your favorable consideration of House Bill 349.
Mr. Chairman, isn't it true that the discretion that this bill would give to the judges in limited circumstances to depart from mandatory minimum is a very conservative concept in the sense that it's efficient in allowing the judge to tailor a sentence for the maximum amount of public benefit and to apply that to specific facts to a defendant?
That's exactly right, and thank you for the question. And just to give a little more detail on that particular aspect, if you look at lines 200 to 206, as I think I set out, the number of people that would affect who would meet just the condition of not having a prior felony conviction constitutes less than 5% of all the individuals who are in our state system today for drug trafficking. When you use the other criteria, they were not the leader of the criminal conduct, no possession or use of the weapon involved, no serious harm to any other individual. The number of those individuals who are even eligible for a reduction, which is not to say they get it, but even would be eligible for a reduction, goes down even further. And that's on purpose, because we want any reduction, any potential reduction, to be very narrow, very limited. Why? Because you're going to have those situations, and we've heard this from our Superior Court judges across the state, as the gentleman knows, you're going to have those very limited circumstances where there may, and may is the key word, there may be situations where an individual caught up in criminal conduct who meet all of those criteria it may not warrant, the facts of that case, to use the gentleman's point, the facts of that case may not warrant 10 years minimum mandatory in the state system. It may warrant 5, it may warrant 7, it may warrant another number, but it could warrant 10. That's going to be up to the judge. Of course, that's why we have judges, to make those decisions on a case-by-case basis. And I appreciate the gentleman drawing that out of me.
I would like to thank you, Mr. Chairman, for all your work on 1176 and also this bill and the work of the Special Counsel on Justice Reform.
Thank you, sir. Mr. Speaker, I'm going to go ahead and yield the well, and I
have no further questions.
Thank you, and I ask for your favorable consideration on House Bill 349.
Shall this bill now pass? All those in favor of the passage of House Bill 349 will vote yes. All those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 349. The ayes are 163, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed.